The Victorian Law Reform Commission has been asked by the Attorney-General of Victoria to review some aspects of succession law, the law relating to wills, property and inheritance, to make sure that the law is operating fairly, justly and in accordance with community expectations. We're keen to hear your views about succession law and how it operates, and we encourage you to watch this interview, look at the consultation papers on our website and make a submission. Firstly, let's have a look at the issues as we see them. Philip Cummins, former Supreme Court Judge, is the Chair of the Commission. Philip, why is the Commission reviewing this area of law?
The death of a person is a time of sorrow. It can also be a time of stress, and the law can add to that stress if the law is not clear and accessible. So the government has referred a number of matters to the Commission to investigate, seeking to make the law more accessible, to make it clearer, to make it fairer. So it's to try and reduce that stress and also to try and prevent conflict after a person has died. It's better to prevent the conflict in the first place rather than to have to resolve it in the courts. But if it gets to the courts, again, the purpose is to seek to ensure fairness and to minimise the costs involved in any dispute.
And what's the scope of the review?
The government has referred 11 specific matters to the Commission for review. The first is the making of wills, and a particular aspect of that which is important is to ensure that there is no undue influence over vulnerable people who are making wills. With demographic changes in society, people are living longer, and there is a question to ensure that older people in particular and other persons are not oppressed by possible beneficiaries.
And do you think people are generally well informed about the importance of making a will?
I think there's a general community understanding of the importance of making a will, but it's not a universal understanding, so there's a matter of education there. There's also, I think, a psychological matter as well, in that considering one's own death is not a comfortable thing for a lot of people, and I think people can put off the thoughts and in particular the arrangements relating to their death. There's a further issue with persons who have not got the legal capacity or the personal capacity to make a will, and the court has to act on their behalf. And one of the matters referred to us is to ensure that the court process is fair and efficient.
And so what happens to someone's property if they don't make a will?
If persons don't make a will, the relevant Act of Parliament, the Administration and Probate Act, sets out a rank order of groups who are entitled to receive the proceeds of the will. First, the partner of the person, then their children, then parents or further relatives. However, it's a one-size-fits-all provision. It doesn't, of course, take into account individual family circumstances or individual personal circumstances. It's just an order set out by Parliament. So it's much better to have a will so that you can direct your own personal situation rather than have an Act of Parliament do it for you. If there are no blood relatives or persons who the estate can be referred to under the Act of Parliament, then the estate goes to the government, but that's a very rare situation. There's nearly always someone who is entitled to receive the proceeds.
So Philip, if someone in my family dies and I'm expecting to get a share under their will and I'm not left anything, or I'm not left as much as I was expecting, is there anything I can do to get a bigger share?
Certainly there is. The law, in particular the Administration and Probate Act, makes provision for claims by people who consider they should have been provided for in a will and weren't, or were not sufficiently provided for. That's what's called family provision, and what can occur is if you consider that you have not been provided for or adequately provided for, you can apply to the court for the court to make specific provision for you, even though it's not in the will. However, that involves going to court, which can be complex and costly. Nonetheless, the right is there to do it. Courts don't interfere lightly with wills, and further, courts don't simply rewrite a will the way the particular judge might think it should have been written. So there are limitations on it. But the bottom line is certainly you can apply to the court for distribution if you have a claim saying you should have been properly cared for by the estate.
So Philip, what costs are involved in distributing a person's estate after they die?
There are quite a number of costs which can occur, such as legal costs, selling a house, conveyancing costs, all of those normal costs which occur in a situation where life changes. The executor who handles the distribution of the estate isn't automatically entitled to a commission unless it's provided for in the will. It's different with the trustee company. When you have a trustee company administering an estate, it is entitled to charge a commission. One of the things we've been asked to look at is the question of costs, because it's plainly most undesirable that estates are eaten up by excessive costs, either of administration or legally or otherwise. And one of the things the reference is directed to is to seek to ensure that estates aren't spent on costs. That's particularly important with small estates, but it's important with every estate.
And so the Victorian Law Reform Commission's carrying out a review of all those aspects of succession law. What's the process involved?
We received the 11 matters from the government that we are to investigate. We do not simply confine ourselves to the specialists in the field, that is to say the courts and the lawyers and the trustee companies. We regard it as central and vitally important to go to the community itself. So we invite community input. We go out into the community and ask the community for its input because these things, although technical and complex, are matters of vital concern to individuals in the community, and we want to get the community input. So community input really is the hallmark of our inquiry.
So Philip, at the end of the process, does the Law Reform Commission have the power to change the law?
No, the Law Reform Commission does not itself change the law. What the Law Reform Commission does is it presents to Parliament its final report, having had the community consultations I've just emphasised, and it's Parliament who has the responsibility for changing the law. However, Parliament has asked the Commission to investigate the 11 matters, and Parliament is conscious that we will have done so, in particular with community input. So Parliament has that in mind when it receives our report, and we therefore would hope that Parliament would legislate in broad lines along what we would recommend.
Okay, thank you very much for that, Philip. The Victorian Law Reform Commission wants to hear from members of the community who have an opinion about these areas of law, but please bear in mind we can't give legal advice on your specific situation. We're releasing a series of consultation papers that you can download for free at our website, lawreform.vic.gov.au. They are wills, small estates, debts, intestacy, family provision and executors. You can respond to one or more of these. Make a submission by email, letter or the website. We look forward to hearing from you.